Delivered 7/21/23. Revisions made 7/20/23. Original not uploaded. To date. Second attempt to make public, like everything else in my case, including all my other letters. Freedom of speech. Mine. All for your review, critique, judgment, understanding. Try it. Clarify. To become or make clear. Clarity. Clearness. Per the Merriam-Webster's dictionary. Where do I even start? Through the officer-inmate grapevine and a letter I received from my fan mail, and usually the only way I find anything out regarding my case since there is no communication from my current attorney, now 10 weeks more of complete silence, and yes, my 6th attorney, which I will clarify momentarily. I was made aware my last letter was featured on the news locally, realistically meaning globally. Apparently, my very legitimate, lawful, real questions and concerns I asked, and am still, caused a stir on top of the already engulfing whirlpool my case has become and made out to look like, which it is not. Hence my previous questions from said letter. I am trying to protect and maintain my truth, which no one knows, since no one else will. However, I can, and keep some of the illicit ugliness at bay. Mismanagement at its finest in everything. Why wasn't I included? At all. Why wasn't I asked prior to being highlighted so I would know what was said or asked or criticized so I could rightfully defend myself? What was so newsworthy? By not including me is unfair and adds to the assumptions of what everyone wants me to end up being and thinks I am. This is wrong and also adds to the prejudgment of my case. All of the idiotic theories, empty opinions, false accusations is all the ignorant world knows from all the pertinent private case details available to everyone except me, the defendant in my case. How can I defend myself? I can't. So everything gets meaner, more evil, corrupt, and out of control. I believe this is what a trial is for, right? The world is supposed to learn everything about my case during the trial, right? This is not justice or a system, right? All fairness has been completely removed, right? So were any of my questions answered? Was anything at all clarified regarding evaluations, amendment violations, case sensitivity, protection, suppression? What's the video hit count reach now? My last letter, it was over 3 million. How much does that shareable income make for everyone? Did anyone locate my attorney or discovery? Everything everyone everywhere in the world knows, has seen, or listened to all of my discovery again except me? In the meantime, here's a corner piece to my convoluted puzzle. All are wondering when it will finally be put together to see what the real picture is. And also a huge disentanglement of only an inkling of some of the misunderstandings and ignorance swirling about in my case. Before you try wearing my slides, know where they've been. My attorneys, 6, when, and as I've said numerous times in my previous letters, why not by choice I am on a 6th attorney. Here's some clarity so everyone can finally have some understanding why my slides are so worn, but most definitely walkable still. Attorney number 1, private, February 2020 to May 2022. This attorney sold me the world, promised exoneration, and supplied an overabundance of other continuous false hopes, so I would accept his offer to become my attorney. He had no idea what my case was going to be or was really about. Then he deserted me, his client, 2 weeks before my first scheduled trial due to irreconcilable differences, meaning I was not persuaded enough to agree with what he wanted me to say or do, and was not what happened. There was no trust. There was no strategy, and if there was, I was never included in on it or an innumerable amount of other case-defining details and questions left unanswered before going to trial. I felt he was sabotaging my case and setting me up for failure due to his micro amount of experience, which I found out after the fact and was not disclosed prior to my acceptance of his representation in my macro-sized case. Nonetheless, when we did meet to discuss my case and I asked for updates about any progress, he would start talking to me about his client in Colombia, his clown of a sister-in-law, his nephew going to water parks, trips he's taken, his regrets, where he bought his gold sneakers, and many other unrelated, unimportant, time-consuming stories. All the while, I'm trying to figure out what's going on and why he's not answering any of my questions. Nothing was ever completed or accomplished or communicated, building 1,000 fires waiting and needing to be put out before making another to be left ablaze. I was always ignored and in the dark, conjuring the dreadful perpetual question mark looming still over my head. So much I prepared an 8-page packet for Judge Wayner. See Wooten. I was always ignored and in the dark, conjuring the dreadful perpetual question mark looming still over my head. So much, I prepared an 8-page packet for Judge Wayner C. Wooten to provide during both court dates, defending myself against my attorney's untrue, unresearched withdrawals. No one asked me nor permitted to speak my truth to help him and the court understand my real concerns along with all the carryover since day one. I was trying to avoid going through any of this again going forward. It had already been 2.3 years. I wanted the judge to include me and know I have a side also in everything. Plus, I knew Judge Wooten would be appointing my next attorney in hopes he would listen and appoint a more suitable, experienced one according to save time for everyone to progressively move forward. He must have been throwing darts at a dartboard blindfolded. This attorney, number one, is untrustworthy, unreliable, unprofessional, with poor leadership skills, and is extremely unorganized. He was unable to perform ethically and as an adult, ignoring his client, misleading and deceiving. He didn't even respect me enough to speak with before his withdrawal to try and remedy or figure anything out to stop. I was totally blindsided. Because of the magnitude of his ineptness and dereliction of duty as a result, withdrawing from my case at the 11th hour after taking over 2 years with nothing I knew of but disappointment, I could have reported him to the Florida bar for legal malpractice. Exhaustion 1. I'm also still waiting on him to release all of my case files and documents obtained and accrued during his representation, including well over 100 pages of my handwritten notes and information, which is irreplaceable. He is still not helping. Him no longer being my attorney was not my choice. Attorney number 2, number 3, number 4. Public defenders appointed by Judge May 2022 through June 2022. Judge Wayne C. Wooten and the court repeatedly appointed me public defenders 3 without any research or care, and after I continuously explained to each and tried to the judge court, they could not represent me due to the representations of the decedent. We've done our homework, I was told. I received 3 withdrawals, none by choice, definitely not systematic. Attorney number 5, conflict, appointed by Judge Court, June 2022 through July 2022. Upon our first and only meeting, this attorney expressed his mass confusion in why he was appointed by Judge Wooten, as he was leaving for a teaching job out of Orlando within the week. I learned more from this attorney in one meeting regarding my case than all prior combined. It was extremely disheartening he could not continue representation and set the bar going forward, especially regarding honesty and respect. I received only 2 letters from him, 1 introduction, 1 withdrawal. He also did not know where any of my discovery was or notes, now 5 attorneys later, not by choice. Attorney number 6, conflict, appointed by Judge Court, July 2022 to present. 1 year mark, 7/11/23, 12 months, 365 days, 52 weeks, summarized. 8 total months, 240 days and counting, are with absolutely no communication in any form, completely inactive. Total amount of hours as court-appointed attorney, over 8,760. Total times met with client, me, 6. Total hours spent with client, 7. Total phone numbers given to client from attorney, 2. Numbers at work, 0. Total time speaking to client via phone, 0. Total number of 15-minute video visits with client, 4. Total number of letters sent to attorney trying to communicate, 8. Total number of letters to the judge trying to communicate my unsuccessful communication with my attorney in hopes he will communicate with him to communicate with me, 7. Letters to other parties to communicate, 3. Total times in court, 3. I was an attempted withdrawal, 2 carryover, and over. The last time I saw my attorney, May 18th, 2023. Where is the progress after 1 entire complete year? Unknown. Everyone, please look on the Orange County, Florida Clerk of the Court's website and see for yourself. Am I looking at it wrong? Reading the contents incorrectly? The mass majority of work seems to be from my correspondence. If not my letters, there's minutes, some live, to view from my non-progressive, lackluster court dates stating the same information and same continuances, and of course none of my comments, concerns, or questions from any. I don't just sit there. Edited, like my case. I feel it important also to communicate to everyone so you understand the undertaking it is for an inmate to attend court and why it is so important to me to have progress to report to make the day count. We are woken up at 3 a.m., taken to a holding cell, and wait plus or minus 4 hours, then taken to the courthouse and put in another holding cell for however many hours until court time for only a 5 to 10 minute opportunity in front of the judge to say anything, if at all. Then taken to another holding cell for however long, transported back to another holding cell, wait however long, then taken to another holding cell, then back to our dorm. Most court dates are court days, spending between 8 to 14 hours for little to no time to speak. It's important to me, us. We matter. Hence my letters. What will be said for this one, I wonder? Like Lois looking to the skies for Superman, I'm hoping, praying for an attorney to step up and truly represent me with honesty, intensity, understanding, respect, and perspective. When they introduce themselves, they can me also, the real me, properly, not the Frankenstein monster I'm being so wrongfully and incorrectly pieced together as from all the propagandized, lucrative defamation and attempted destruction of my character and still intact integrity. Clearly, also, everyone can see all of the aforementioned information regarding my attorneys was never a strategy of mine, nor will be. Is it a strategy of the judge and court? Judge Wooten, will I be included, please, in my upcoming status hearing prior to my PTC, which is also the 1 year mark of attorney number 6 on 7/11/23? Will I be permitted? I was not. Attendance from you, like all the news channels and professional YouTubers. I hope I finally see my attorney, whom will, I'm sure, tell me, as you so graciously explained to me in my last PTC I was made a part of, consuming my minute minutes of your invaluable time, that you and he have other clients. I am a client and have been for over a year with this attorney and paid tax dollars to utilize all of my available resources, including and not limited to a state or government attorney appointed by the court. And you will always have clients. You never know when you may become one yourself. Please do not discredit my truth. I am who, not what. Respectful and diligent, Sarah Boone. Mr. Bankowitz, I am writing in regards to not hearing from you and am becoming very concerned after receiving no response to any of my daily calls or from the letters I've sent. As of today, October 3rd, you have been my court-appointed attorney for almost 3 months, 12 weeks, 84 days, and only spoken to me 3 times. 7/14/22, video introduction, 15 minutes. 8/2/22, video update, 15 minutes. 8/22/22, visit in person, 90 minutes. I have written 2 letters in the meantime. Also, my most recent I sent on 9/12/22 with no response. I am unaware of the difficulties you are having in communicating with me, video, phone, letter, in person, especially via phone, which to me is the simplest form of doing so, even if just for a brief update, which takes only minutes. I believed by you giving me your personal cell number, you were going to answer. I would at least know all is well and have a better understanding of the status of some things, what to plan on or what I might need to work on. With no communication makes my end more difficult, drawn out, and painful. Please figure out whatever necessary for my phone calls to be answered, which you will be reimbursed for when you submit your costs. It feels at this rate of communication and meetings, and you are just coming on board, not having all of my discovery to go over, still on top of everything else to be done and depth. How much longer am I really going to be here added to the 32 months already? Especially if we communicate, however, you eventually do only 1 time a month, if that. As for all of the month of September, I know nothing from not hearing from you. I understand you have other clients, as I am one also, and you've been recuperating from your back. But remember, please, how long I've been here, okay? You are my 6th attorney, not by choice. And the magnitude of my case, with not knowing what's going on or where you are, how much harder it is for me. I want to get on with my life, Mr. Bankowitz, and not miss any more time necessary for my son. I've already missed 4 of his birthdays and spent 3 of my own in here. Please understand. No, too, I am patient. Clearly, after all the time already invested, and still smiling and willing to go above and beyond whatever I need to do to properly and truthfully convey my very convoluted, misunderstood side of everything, which I boldly told you in our meeting last month. I am dedicated, ready to start, overdue. I am so very grateful, Mr. Bankowitz, for you, all you are doing, have done, and will do. We're in this together, and I'm so blessed you are my attorney. God has put us in each other's paths for a reason, and I can't wait to see what you and he will do. I'm praying the 6th time's the charm. Please respond. I await your response. Thank you profusely, Sarah Boone. Honorable Judge Wooten, forgive me in advance for having to utilize your invaluable time to ask the current progress of my case. But after not having any form of communication with my attorney appointed by you, now after 11 weeks, and counting after sending 4 letters to my attorney appointed by you with no response, and after finally finding an outside resource to inform me of the uneventful, confusing filed documents online by my attorney appointed by you, I am still waiting with a perpetual question mark over my head. No letters, no video visits, no face-to-face visits, no answered phone calls from my attorney, or even a response from you, Your Honor, regarding one of my letters expressing my legitimate concern of what's going on in my case. And where's my attorney? It has now been over 4 months since being appointed another attorney, number 6, and not by my decision, influence, or choice, and almost 3 of the 4 months not hearing from said attorney. Why? What is the reason? Why haven't I received a letter, even a 15-minute video update, anything? Even after my PTC on 10/25 is what truly confuses me and nonetheless upsets me. The fact I was not in attendance so I could know what's going on in my case, especially considering I have not heard from my attorney in 11 weeks and should have been included. Why was I not? This is my case? Was Mr. Bankowitz even there to represent me? I don't know. Anything. Still. The problem is that my constitutional rights are incorrectly being waived without my knowledge or permission. I've never signed anything nor verbalized the idea I wish to waive my appearances to any of my court dates. I want to be present for all dates going forward, please, regardless the significance. All are significant to me, since my attorney fails to relay any information in any way. If he's not going to, then I must myself and for myself, as always, my entire life. What else can I do? I have you and God, Judge Wooten. If I do have an attorney, where is he? There's so much to do all over in my case, hopefully the right way this time. Off to a rocky start, where I wonder how more extended my time will be on top of the almost soon to be 36 months. 3 years already. Is this how the justice system really works? Am I being penalized for wanting to be fully involved in everything and intelligent enough to know how my case is being handled is unjust? And from my point of view, disastrous, considering I'm still here sitting in Orange County Jail counting the days and praying my 6th attorney contacts me and we can move forward, finally coming to an end. This seemingly endless debacle. You would think, considering the circus show my entire case is being made out to be, with all the hype, sensationalism, and publicity, I received a letter all the way from across the pond, England, the other day. It would be being handled more professional, better. I learn something new every day about facts, events, and outcomes in my case from all the inmates and officers as well. I wonder if they might know where my attorney is. Bottom line, please understand, I don't want to be here any longer. I don't want to be hindered any longer in getting just to the starting line. Again, I don't want to be suppressed in being heard. Finally, truthfully, and correctly. So when, Judge Wooten, when will I hear from my attorney? Or you, please, just with some type of response other than a copy of my letters I keep sending, which I already have. In the meantime, it is my understanding the following documents have been filed in my case since the appointment of Frank Bankowitz, my attorney, MIA. 7/11, Bankowitz appointed. 7/12, PTC order, pretrial 10/25, trial 11/7. 8/29, pretrial canceled. 9/23, notice of unavailability. 10/7, correspondence, my letter to Bankowitz. 10/12, correspondence to defendant, copy of my letter. 10/24, notice of appearance. For what? Had 3 years ago. Not guilty plea. Already filed. Waiver of appearance. Never signed. Agreed to. Compensation for what? What's been done? 10/25, substituting conflict counsel. Who was my attorney? 10/25, PTC 1/17/2023, trial 1/30/2023. That's it? In the almost 4 months I've been a client of Mr. Bankowitz, this is the only progress? What's next? Where are my copies of everything filed ever? This is one way I can have some idea of what's happening. And please remember, I have no access to a computer nor any reliable outside resource to check anything for me. Please mail copies. I'm trying to come up with any solution possible to keep me, the other party in my case, informed and updated. This also is a part of the court's responsibility. I would especially think knowing I've not heard from my attorney in any way for 11 weeks plus. I want to be included. As always, I thank you for your time and understanding. Please help however you are able. I am not helpless. I am ready to get this show on the road and to hear from someone other than myself asking the same question over and over and over. What's going on in my case? Or how many more pens will I exhaust asking? Grateful and patiently waiting. I await your response. Sincerely, Sarah Boone.
Mentor lawyer, swimming with the sharks with an official update about the Sarah Boone case. Yes, our dear Sarah Boone is not going to trial next week. The trial was supposed to happen next week in Orlando, but today Judge Wooten officially granted a motion for continuance. He is set it for October of this year, but Sarah's attorney already gave the judge indications that the case is not going to be ready for trial even in October. All right, so let me explain to you guys the whole issue about the continuance. This is what happened, okay? The issue is that Sarah Boone wants to present a defense of battered spouse syndrome. And for that, she has hired an expert finally. But remember, she's an indigent for costs person. Basically, the state of Florida has to pay her costs. That is done through the JAC, the Judicial Administration Commission. And the Judicial Administration Commission has schedules and limitations on compensation. The expert that was retained to examine Sarah Boone for the purpose of the defense wants to be more fairly compensated than the small flat fee that the JAC is willing to pay. So a motion was filed asking for higher compensation for this expert with an explanation why that is needed. The JAC, Judicial Administration Commission of the state of Florida, filed an objection, and therefore a hearing will be required on that issue. That's what's caused the delay. The hearing will be happening apparently in September. The court will then decide whether to allow this additional expense and whether the JAC has to pay for it. If granted, the expert will be deposed by the state of Florida as well. So all of this is going to cause delay in the case, and that's why the judge granted a continuance. We'll see. Maybe the case will finally go to trial very, very late in the year. But Sarah Boone's wishes are not coming true. Sarah Boone wrote another letter to the judge, sent it to the clerk, and it was not appearing on the court file. So she brought a copy with her to the hearing. The judge allowed her to speak, and she explained that she had written a new letter and that it wasn't on the clerk's website. So she demanded nicely. She actually spoke with some respect to the judge. She asked that the letter be put in the court file, so of course the public can take a look at it and see all her complaints about the horrible justice system that we live in. I personally think that her attorney should at least file a motion to try to get her released out on bond while the case is being prepared for trial. She's not being charged with first-degree murder. I think that she should at least deserve a bond for the time that she's waiting for trial, but she might not be able to afford the bond. That's how the justice system works. So the bond would still be pretty high, and maybe she just cannot afford it. And so it would be a waste of time to ask for a bond. So in any case, that's the update. I'm going to have actress Sarah Priebus read the new letter as soon as it's available. And I'm going to try to, of course, cover the trial when it happens.
Which continues to prepare your defense, right?
Judge Boone, I understand, and I'm grateful for your time. I had previously sent you a letter, and it has not been uploaded, but it was made an announcement to the courtroom during my pretrial that you do have it, and I was wondering why and if it will be uploaded, because I have another copy of it that I would like to hand deliver to you today.